I've got 10 minutes. I've got some notes in front of me here. I'll watch the clock. And I think after each of us makes our presentation, there'll be a more broad range of discussion. I think that's how Philippa wants this to go for this afternoon. Can I just say at the outset that what I want to do for the first 10 minutes, essentially, is lay a bit more of a platform rather than coming out straight away and say, I like it or don't like it. I want to take us back a few steps to say, where did this come from, where is it now, and where might it be going, and then leave it to David, to Peter, to follow those themes, and then come back and have a discussion around the actual bills. There are more than one because they have to sort of tie in with other human rights and other legislation. So what I want to do at the start is just talk about freedom of religion and belief generally in Australia, where it's come from, and then that'll help us locate where we are currently, where the legislation is going to be going sometime during 2020. Let me start with this proposition that we often say that essentially in Australia we have a separation of church and state. And that comes essentially from section 116 of the Australian Constitution that sort of says that. When I say it sort of says it, because it's in 19th century language, and it essentially says two things. One, there won't be a state religion, and two, there won't be any way that a religion can determine what it is that we have to do, and sort of allied to that, no one can dictate to religions what they have to do. So it's a kind of a 19th century view of separation of church and state, outline of the Constitution, section 116, it's there. We don't often refer to it because it's really a very broad statement. There's no meat to that statement. Having said that, I'll put my proposition and say, in fact, we don't have a separation of church and state. We actually have a very strong interweaving of church and state, and I call it a symbiosis. That is, the church helps the state, and the state helps the church. And so the first 2 or 3 minutes of my talk, I've listed about 10 dot points here, very quickly, about the interrelationship between the two, which is, I maintain, integral to our civil society. I'm not saying it's a bad thing, I'm actually saying it's quite a good thing. So, for example, as you know, every parliament, state and federal, at the opening of every day, has a Christian prayer. Now, not a multi-faith prayer, I should add, but a Christian prayer and the Lord's Prayer. We have school funding for religious schools, state funding for religious schools. That wouldn't be acceptable in a complete church and state separation. We have a whole range of legislative protections, which we can go through a bit later, in our equal opportunity and anti-discrimination legislation that actually allows churches to do discriminatory things, to say priests can only be men, for example. So there's all sorts of ways in which the anti-discrimination legislation has exemptions for religious orders. So that wouldn't happen in a complete separation of church and state. So some of those other protections are gender, sexuality, in the training and education of ordinands, etc. However, there's a little rider to that, so long as what happens is in accordance with the precepts of that religious organisation, and that's well known. You can't just sort of make it up and say, oh, we decided that yesterday. In other words, it has to be fairly well known or fairly understood as one of those precepts. We also have a whole range of legislation that prohibits discrimination against people expressing certain religious views. Here in South Australia we have legislation saying you can't discriminate against a person on the basis of their religious dress. So a Sikh turns up in your organisation, you can't say, sorry mate, no turbans allowed here. That would be discrimination, and that's prohibited. We have tax exemptions for religious charities. We have, in the Evidence Act, until recently, here in South Australia and Victoria, which gave complete immunity from the evidence that was required to be given by what was said in the confessional. As you know, last year that came to a head when the Attorney General changed that rule. I'm not sure it has any effect, but it changed the rule concerning the divulgence of what occurred in the confessional. But the Evidence Act protects that in every other state from being divulged under the evidence rules. People who are ordained don't have to become marriage celebrants just by virtue of their ordination. They can carry out their marriage rights under the Marriage Act. We have conscience votes, which are essentially around religious themes in our parliaments. And for the most part, I'm told, and Peter might help me here, that something like 2/3 of welfare payments, other than pensions, are paid by government money through welfare agencies. So what I'm protecting at the moment is the idea of civil society needing the state and religion to be in league with each other. In other words, one really can't survive without the other, and I'm maintaining that's a good thing. So governments need religious organisations benefit very much from government decisions. So when we're talking about freedom of religion and belief, we start with that proposition that they are not aloof from each other. They really are very much in league with each other. And in fact, of course, you can also add the fact they can't be aloof. If a person is being sacked unfairly on the basis of some commercial activity within a church, the state can intervene to look at that contractual matter. If, of course, a priest or anyone else, for that matter, engages in criminal behaviour, a la what's been happening in the last 30 years in relation to the sexual abuse of young children, etc., the state can obviously intervene. We have George Pell behind bars at the moment, subject to what might happen in the High Court appeal in the next couple of months. So clearly, you don't have an aloofness. You can't say, well, I'm a religious person, therefore the state's civil laws and criminal laws don't apply to me. Obviously they do. So all of this was very much a sleeper. This was just sitting there. This has been the case for the last 100 years, just sitting there with this kind of symbiotic relationship, one needing the other and the other needing the other, until such time as you all know, I'm sure, refresh your memory, going back a couple of years, when along came the marriage equality debate. And the marriage equality debate came along saying, well, why shouldn't the term marriage also apply to same-sex unions? Now, I can tell you from a legal proposition that over the last 15 to 20 years, there's not one aspect of a union of same-sex couples which is not now legally recognised in terms of the sharing of assets, the way in which trusts are set up, the pension arrangements are set up. In other words, if you've got a same-sex union, everything now legally is the same as if you were married. 100 years ago, that was never the case, of course. But now that's all just changed to protect same-sex unions. The only thing they didn't have was the ability to call it a marriage. And of course, that's where I'll say the fight began, going back to probably a couple of years now. Of course, that then came before the federal parliament. Malcolm Turnbull decided he was going to stake his prime ministership on putting this through. He needed to get the naysayers and the Conservatives to say, come along with me on this one, trust me on this one, we can actually change the Marriage Act. I should go, oh gee, I'm running out of time, but I'll go back another 10 years or so, where John Howard in fact had altered the Marriage Act because he needed to put in the word man and a woman. In fact, as you may know, there are 4 things, I better remember off the top of my head here, that are required when you are doing your vows in a marriage ceremony. It must be for life, to the exclusion of all others, and voluntarily. That comes out of the Marriage Act. You must put that in the vow somewhere. And indeed, it was always that was between a man and a woman. It comes out of a famous English case going back to the 1860s called Hyde versus Hyde. Upon that definition, the 1961 Marriage Act was based. But John Howard realised that the Marriage Act didn't have the word man and a woman in there because everyone thought it was always going to be a man and a woman. So he decided to stick man and a woman into the Marriage Act about 10 years ago to make sure that we couldn't have same-sex marriage. Malcolm Turnbull wanted to remove those words. Hence, the legislation was coming along to do just that. As a result of a few naysayers coming to him, he said, don't worry, let's pass this legislation. This happened in November 2017. We'll pass the legislation. There are only 4 people who voted against it. And he said, as a result of that, I'll get Philip Ruddock to engage in a process throughout 2018 to look at the whole question of religious freedom, because this came down to the fact that more conservative Christians were saying, you can't touch this, if not Christians, other faiths as well. Don't touch this, marriage is marriage, it can't be between same-sex couples. So it did come up there, boiled up and bubbled up as a religious freedom issue. Religious freedom then was on the agenda for the Philip Ruddock Commission with a whole range of other lawyers and human rights people, and their report came out in the middle of 2018. Well, it sort of came out. It actually came to Malcolm Turnbull while he was still Prime Minister, but wasn't released until December of 2018. Why? Because at that stage we'd now had ScoMo coming on board in August 2018, and he was going to have a closer look at it than Malcolm Turnbull because of his kind of credentials, which are a little bit more charismatic and evangelical than Malcolm Turnbull's Catholicism, converted Catholicism I should add as well. That being the case, they left 6 months for this thing to be under wraps so that he could prepare his response. And then in December 2018, the report was released, as a result of which, you might recall, heading towards the 2019 election, ScoMo said, don't worry, this will be an election item. It never was. It never came up. All he ever said was, we're going to have some freedom of religion stuff that's going to be based upon what Philip Ruddock has said, and it's going to be important, and we'll get it right because vote for us. But no one ever saw anything of it before the May 2019 election. After the 2019 election, what happened? They took the Ruddock report. Ruddock at no point had ever said there ought to be some legislation called the Freedom of Religion and Belief legislation. ScoMo's run with that. He then had to have a choice. The choice was, would he go with the Conservatives and come out with a positive right that said you have a right to be religiously free, or the alternative was always going to be, we won't actually dictate a right, but we'll bolster some other things. We'll actually bolster the idea of being protection from religious discrimination, and we'll bolster the idea that maybe there could be some ways in which a person expressing certain views would not offend anti-discrimination legislation, which has been around for 40 years. So the Conservatives are angry with him. They're angry with him, angry with the Christian Porter Bill, the first one, the first iteration, saying it should have had a positive right to express your religious freedom. It doesn't. The non-progressives, the atheists and the secularists and maybe the more progressive Christians were saying, actually, no, it goes too far. It now will allow more bigoted statements to come out as a result of a person saying, all I'm doing is expressing my religious belief. So we're stuck with that now. What happened politically? Politically, Christian Porter came out, it was about August of last year, with the first suite of bills. They went out for consultation. They were reworked after an initial consultation back in October. They went back for a second round of consultation in an amendment form, which cut off at the beginning of February, I think. And we now have more legislation coming forward which we haven't seen yet. But the important thing to know about that legislation is it doesn't come out, at no point does it come out and say there will now be a right to religious freedom, which is what the Conservatives wanted. And in some respects, the naysayers in the marriage equality party room in the coalition, that's what they kind of expected Philip Ruddock to say, so they're feeling a bit aggrieved by that as well. But it does have some fairly strong views. One, about good things, about not being discriminated against or vilified against on the basis of your religious belief. But secondly, it does now just offer a few more windows into the possibility of saying something which is religiously bigoted. I'm going to finish with one little illustration which I maintain is probably a good little illustration of the way in which it is possible to go. Then I'll pass over to Dave and Peter to pick up on this. Some of you may remember that one of the test cases of this was Archbishop Porteous in Tasmania going back about 3 or 4 years. It was at the beginning of the debate around marriage equality, and he produced a leaflet which he distributed to parents at Catholic schools in and around Hobart. So it wasn't more widespread than that, it was actually sort of private to that extent. And basically it was headed, "Don't mess with our kids." And basically it was saying, if you vote or if you favour this idea of same-sex marriage equality, giving marriage status to same-sex couples, whether they're male or female, what you're doing is you're screwing up our kids. They won't have the mother and father that we all know is far better for raising children. So he put this in a leaflet. It was challenged under the Tasmanian Anti-Discrimination Act. The Anti-Discrimination Act says you can't discriminate against a person in relation to their sexuality, and clearly if you're saying something about same-sex marriage, which is essentially saying it's screwing up with kids, then you're offending the anti-discrimination legislation in Tasmania. So this person was able to bring this action against Archbishop Porteous because that was the actual wording of the anti-discrimination legislation. Archbishop Porteous went livid with this, saying, wait a minute, all I'm doing is expressing my freedom of religion to say that that's what I believe the Lord says about the sanctity of marriage, not to have it between same-sex couples. Now, unfortunately for us, it didn't go to the Tasmanian Supreme Court because we might have got some law out of that. It was sort of shuffled off for some mediation and finally everyone quietened down, and the discrimination claim was withdrawn as part of that conciliation arrangement. But I'm thinking that my brethren here will probably agree with me and say that if this new iteration, although we haven't seen the final version of it, of the Christian Porter legislation now with the religious freedom of belief bills coming through, my guess would be that that sort of statement will now become, if not commonplace, certainly will not offend anti-discrimination legislation. So my view would be that, in summary then, I think the sleeper that was always there prior to this whole issue erupting was probably a good way to balance that kind of non-separation of church and state. I think the legislation got it about right. Yes, there's some other issues around homosexuality and maybe the idea of offending a bunch of people who are in relation to same-sex or homosexuals in teaching might have given rise to some problems that needed some tweaking. But I'm firmly of the view that the new bills coming forward now will probably allow a lot more bigoted statements to come out and relate to them and in a way that will be protected by this legislation. But until the legislation comes out, we're not going to be sure. That's my overview of where we are now. It's probably a good opportunity to pass both on to David and to Peter to follow that through.